Foreign Corrupt Practices Act out of the old version of the Reference Guide to Regulatory Compliance on page 821. This comes from Part 15 of the United States Code, Section 78. The Foreign Corrupt Practices Act of 1977, the FCPA, seeks to stop bribery of foreign government officials by U.S. companies for the purpose of facilitating favorable action. During the decade in the 1970s, several hundred U.S. companies and persons acting on their behalf were found to have bribed government officials in foreign countries in order to facilitate business in those countries. The FCPA was enacted to prevent this behavior from happening and restore integrity in the U.S. business system. The law makes it a crime to offer, make, or authorize a payment or anything of value to an official of a foreign government or through an intermediary to induce the official to use his or her position to direct business to the payer or another person. There are also accounting provisions of the law that require publicly traded U.S. businesses to maintain controls on assets and accurately record them. The purpose of the accounting rules is to prevent such practices as maintaining slush funds to make illegal payments. The Department of Justice is authorized to enforce the criminal provisions of the law. The SEC administers the accounting provisions. The law applies to any company or person acting on behalf of the company, its officers, directors, or shareholders, or anyone acting on their behalf. The law was amended significantly in 1988 and 1998 its reach was broadened to cover foreign persons or officials who engage in corrupt act while in the United States. So that should be reflected in subpart 1, the covered section. For foreign officials, any officer or employee of a foreign government, also including any department, agency, or instrumentality of a foreign government, including any person acting in any official capacity for or on behalf of a foreign government, and any officer, employee, agency, or instrumentality of a public international organization is defined as a foreign official covered under the Foreign Corrupt Practices Act. Domestic concern, B, under coverage, includes an individual who is a citizen, national, or resident of the United States, a corporation, partnership, association, trust, unincorporated business, or sole proprietorship that has its principal place of business in the United States or is organized under U.S. laws or the laws of any state. Actions in interstate commerce means trade, commerce, transportation, or communication among several states or between any foreign country and any state or between any state or any place or outside thereof, and such term includes the intrastate use of telephone or other interstate means of communication or any other interstate instrumentality. The requirements under the FCPA starts with prohibited trade practices by domestic concerns, where it is unlawful for a domestic concern or any officer, director, employee, or agent of the concern or any stockholder acting on behalf of the domestic concern to use the mails or any means of interstate commerce corruptly to further an officer, payment, promise to pay, or authorization of the payment of any money, offer, gift, or authorization of the giving of anything of value to any of the following for the purpose of assisting the domestic concern in obtaining or retaining business, or for the official, political party, or party official to direct business to the domestic concern, any foreign official to 1. Influence any act or decision in his official capacity, 2. Induce such official to do or omit to do any act in violation of his lawful duty, 3. Secure an improper advantage, and D. Induce the official to use his influence to with a foreign government to affect or influence any act or decision, and 2. That prohibited is any foreign political party or official of such political party to influence any act or decision or the party or the official. Induce the party or official to do or omit to do any act in violation of the lawful duty of the official or the party, secure any improper advantage, and induce the party or official to use influence with the foreign government to to affect or influence any act or decision. Part B under requirements includes prohibited trade practices by issuers. Thereby, it is unlawful for any corporation with securities registered in the U.S. or which it is required to file periodic reports with the SEC issuer, also known as issuer, or for any officer, director, employee, or agent of the issuer to, or any stockholder acting on behalf of the issuer to use the mails or any means of interstate commerce corruptly to further an offer, payment, promise to pay, or authorization of the payment of any money, offer, gift, or authorization of the giving of anything of value to any of the following for the purpose of assisting the issuer in obtaining or retaining business, or for the official, political party, or party official to direct business to the issuer. And that includes any foreign official to influence any act or decision in his official capacity, induce such official to do or omit to do any act in violation of his lawful duty. 3. Secure an improper advantage. Or 4. Induce such official to use his influence to with a foreign government to affect or influence any act or decision. 2. Any foreign political party or official of such political party to influence any act or decision of the party or the official. Induce the party or official to do or omit to do any act in violation of the lawful duty of the official or the party. Secure any improper advantage, or induce the party or official to use influence with the government to affect or influence any act or decision. Part C under requirements reads, prohibited foreign trade practices by persons other than issuers or domestic concerns, and it is unlawful under the section for any person other than the issuer or a domestic concern, or for any officer, director, employee, or agent of the person, or any stockholder acting on behalf of such person while in the territory of the United States to use the mails or any means of interstate commerce corruptly to further an offer, payment, promise to pay, or authorization of the payment of any money, offer, gift, or authorization of the giving of anything of value to any of the following for the purpose of assisting the issuer in obtaining or retaining business, or for the official political party or party official to direct business to that person. That includes any foreign official to A through D. A. Influence any act or decision of in his official capacity. B. Induce such official to omit to any act in omit to do any act in violation of his lawful duty. C. Secure an improper advantage. Or D. Induce such official to use his influence to with a foreign government to affect or influence any act or decision. Or 2. Any foreign political party or official of such political party to influence any act or decision or the party of the official. B. Induce the party or official to omit to any act in violation of the lawful duty of the official or the party. C. Secure any improper advantage. Or D. Induce the party or official to use influence with a foreign government to affect or influence any act or decision. Exceptions. 1. All of the restrictions on foreign trade practices are subject to the exception for routine governmental action. 2. Routine governmental action means an action that is ordinarily and commonly performed by a foreign official in A through E. A. Obtaining permits, licenses, or other official documents to qualify a person to do business in a foreign country. B. Processing governmental papers, such as visas and work orders. C. Providing police protection, mail pickup and delivery, or scheduling inspections associated with contract performance or relating to the transit of goods across the country. And D. Providing phone service, power and water supply, loading and unloading cargo, or protecting perishable products or commodities from deterioration, or lastly, actions of a similar nature. 3. Routine governmental action does not include any decision by a foreign official to award new business to or to continue business with a particular party, or any such action to encourage a decision to award new business to or continue business with a particular party. Subpart E. Affirmative defenses to claims of corrupt foreign practices. It is an affirmative defense to actions under the FCPA that 1. The payment, gift, offer, or promise of anything of value was lawful under the written laws or regulations of the foreign officials, political parties, party officials, candidates, country, or the payment, gift, offer, or promise to pay anything of value was a reasonable and bona fide expenditure, such as travel and lodging expenses, incurred by or on behalf of a foreign official, party official, or candidate, and was directly related to the promotion, demonstration, or explanation of products or services, or the execution or performance of a contract with a foreign government or agency thereof. Duties of issuers, subpart F, under requirements 1 through 4. 1. Periodic reports to be filed. Every issuer must file such information and documents as the Securities and Exchange Commission will require to keep reasonably current the information and documents required to be filed. 2. Annual reports to be filed. Every issuer must file such annual reports as required by the rules and regulations of the SEC by independent public accountants, and such quarterly reports and such copies thereof as the SEC may prescribe. 3rd, information filed with securities exchanges. Every issuer of a security registered on a national securities exchange must also file a duplicate original in the information documents and reports if the exchange with the exchange. And 4th, accounting requirements A and B. A. Issuers must make and keep books, records, and accounts which accurately reflect the transactions and dispositions of the assets of the issuer in reasonable detail. And B. Maintain a system of sufficient internal accounting controls in order to provide assurances that 1 through 5. 1. Transactions are executed in accordance with the management's authorization. Transactions are recorded as necessary to permit preparation of financial statements in conformity with generally accepted accounting principles. 3rd, transactions are recorded sufficiently to maintain accountability for assets. 4th, access to assets is permitted only in accordance with management's authorization. And 5, the recorded accountability for assets is compared with the existing assets at reasonable intervals, and appropriate action is taken with respect to any differences. Penalties and enforcement include injunctive relief, penalties for domestic concerns, penalties for non-domestic concerns, and penalties for failure to file reports or keep appropriate records. Injunctive relief reads, Attorney General can request injunctive relief when it appears that a domestic concern officer, director, employer, or stockholder is about to engage in activities that would violate the law. B. Penalties for domestic concerns are up to a $2 million fine for a domestic concern who is not a natural person, and up to a $10,000 civil penalty for a domestic concern who is not a natural person. Up to a $100,000 fine, and up to 5 years in prison for a natural person who is an officer, employee, director, or shareholder of a domestic concern, and fines for individuals may not be paid directly or indirectly by the domestic concern. Penalties for non-domestic concerns are once again up to $2 million for a person who is not a domestic concern or a issuer who is not a natural person. 2, up to $10,000 civil penalty for a person who is not a domestic concern or an issuer or who is not a natural person, and up to $100,000 fine and up to 5 years imprisonment for a natural person who is an officer, employee, director, shareholder of a person other than a domestic concern or an issuer. And 4th, fines for individuals may not be paid by the organization. D. Penalties for failure to file reports or keep appropriate records is a $5 million fine or imprisonment up to 20 years or both for filing materially false statements, and $25 million for filing a false statement for non-natural persons, and $100 a day for failure to file required information, documents, or reports.